The word in the petition was volatile, not unstable, which I could have fought, and not unfit, which is what people assume when I tell them, and which does not actually appear anywhere in the document. Volatile. A woman of 41 presenting a volatile home environment inconsistent with the minor child's established need for continuity. I read it standing in my own hallway on a Tuesday in February with my coat still on, and my daughter's swimming bag over my shoulder, because the process server had timed it for 6 o'clock, which is when everybody in this country is walking back through a door with a bag in their hand. 11 pages, petition for grandparent visitation. In the matter of the minor child, I.R. Rook. I.R. Rook is Imogen. She was 11. She was in the car outside with a wet towel and her hair frozen because she refuses to dry it in February, and she was waiting for me to come back out with the house keys so we could get the shopping in, and I stood in the hallway for about 90 seconds reading the word volatile over and over. Then I put the paper's face down on the shelf, where the post goes, and went out and got the shopping in. If this is your sort of story, take a second and subscribe to Revenge Lab. And tell me in the comments whether anybody has ever done something to you and dressed it up as concern, because I would very much like to know I am not the only one. Now, back to it. My name is Neve Rook, and I have been a widow for 7 years. Toby died on the 8th of November when he was 36 and I was 34, and Imogen was 4 years and 2 months old. A single vehicle collision on the Fenwick Road at 11 at night. No other car, no alcohol, nothing on the toxicology, wet road and a bend that has taken 3 people since 1998. I am a school business manager, which means I run the money and the buildings and the staffing for a primary school of 211 children, and it is a job nobody has ever understood at a party. I have not remarried. I have not particularly wanted to. There was a man for about 14 months in 2022 who was kind, and who I could not make room for, and that is the entire romantic content of this account, and I am telling you now so you are not waiting for it. And my mother-in-law is Camilla Rook, who is 71, and who I had protected for 7 years without ever once telling a living soul that I was doing it, which is why her lawyer's petition made a claim about me that nobody in that courthouse could have known was the exact reverse of the truth. I want to describe Camilla properly, and it is going to take a while, because if I give you the version people expect, this will be a story about a monster, and it is not. She is small and beautifully turned out, and she has a laugh that makes strangers look over and want to be included. She was a district nurse for 31 years, and she was, I am told by about 40 people, extremely good at it. She remembers everything. Birthdays, the names of your colleagues, the operation your father had in 2019. She sends cards. She sent me a card on the 8th of November for 7 consecutive years, and every one of them was thoughtful and none of them was easy to write. And she is the most frightened person I have ever met. That is the thing it took me 11 years to see, and about 4 years to be able to say without it sounding like an excuse. Underneath the cards and the laugh, and the 31 years of nursing, there is a woman in a permanent state of low-grade terror about being left, and every single thing she does that looks like control is actually that. Toby understood it completely. He used to say she was not manipulative, she was drowning, and drowning people climb on you. He also moved 200 miles away at 23 and did not move back, which is a sentence he never once connected to the other one. Here is what happened on the night he died, and I need to put it here rather than later, because everything else in this account is built on the fact that I have known it for 7 years and never said it. Toby drove up to Camilla's on the Saturday. On his own, which was normal, he went about every 6 weeks and often took Imogen and sometimes did not. He was supposed to stay the night. He always stayed the night, because it is 2 hours and 10 minutes each way, and he was not an idiot. He left at 10:20. He rang me from the car at past. I have the call in my phone log, and I have never deleted it, and I will never delete it. 4 minutes and 11 seconds. He was not upset in the way people mean. He was flat. He said, "I'm coming home tonight." I said, "Why?" And he said, because if I stay, we're going to keep going, and I'll say something I can't take back." I said, "What did she say?" And my husband said, "She said if I really loved her, I'd move back, and that Neve's got you now and she's got nobody, and that when she's dead, I'll be sorry I chose a woman I met at 29 over the person who raised me." Then he said, "I'm fine. I've had one glass at 6 and nothing since. I'll be back by 12:30. And then he said the last thing he ever said to me, which was not "I love you," which is the thing people always want it to have been. It was, "Don't wait up, you've got parents' evening." He came off the road at the Fenwick Bend at 11:04. I did not tell anybody. Not the police, who asked what his state of mind had been and to whom I said he was tired. Not the coroner at an inquest that took 11 minutes and returned accidental death. Not my mother, not my sister, not the woman at the bereavement service, not the man in 2022. And above all, not Camilla, who asked me, at the funeral, in the corridor outside the crematorium chapel, with both her hands around mine, whether he had been all right when he left. And I said he was fine. He was completely fine. He just wanted his own bed. That is the largest and most deliberate lie I have ever told, and I told it 11 days after he died, and I have maintained it, without a single wobble, for 7 years. I want to be honest about why, because the noble version is not the whole of it. Some of it was mercy. That is true, and I am not going to pretend it out of some need to seem hard. She had lost her only child, and she was going to have to live another 20 or 30 years, and the difference between a son who died on a wet road and a son who died driving away from an argument she started is the difference between grief and something a person does not come back from. Some of it was Imogen, 4 years and 2 months old. Grandmothers matter, and I did not want my daughter to have a grandmother she was frightened of, or worse, one who had been quietly written out and could not be asked about. And part of it, the part I did not look at for about 5 years, was that as long as I was the only person who knew, I had something. Not power exactly, but the shape of power. Every time Camilla was difficult, and she was difficult, constantly, in small deniable ways for 7 years, I had, sitting in my chest, a completely true sentence that would have ended her, and I never said it, and knowing I could was a kind of furniture I arranged the room around. I am not proud of that, but a person who says they kept a secret like that for 7 years out of pure kindness is not telling you everything, and I said at the start I would. The 7 years were not a war. That is what makes the petition so strange to explain. We saw her about 8 times a year. She came at Christmas and stayed 4 days. She came for Imogen's birthday in September. There were 2 or 3 weekends a year when we drove up, and Imogen went for a week most summers from the age of 7, on her own, on the train with a lanyard, which Camilla loved and organized militarily. And in between, there was a phone call every Sunday at 6, which Imogen took, and which lasted between 11 and 40 minutes depending on my daughter's mood. I made every one of those things happen, every single one. Camilla has never in 7 years arranged a visit. She has expressed a hope that one might happen, at length, in a way that requires the other person to produce it, and I produced it 8 times a year for 7 years. I booked the trains. I drove the 2 hours and 10 minutes. I remembered the birthday. I bought the presents from Imogen and wrote the label in my left hand so it looked like a child's. I rang on the 8th of November every year before she could ring me, because I had worked out in the 2nd year that she needed to be rung and could not ask. And I did all of it while being the only person alive who knew that her last conversation with her son had been the one that put him on that road at 11 o'clock at night. I have to go further back than the Fenwick Road, because the 8 years before it explain why a sentence on a telephone was able to do what it did. Toby and I met in 2007. He was 25 and I was 23, and it was at a wedding, which is embarrassing and true. He had moved down at 23, 2 years before, for a job that he stayed in for 11 months and then left. He never moved back, and it was never discussed as a decision. It was simply the arrangement, and by the time I met him, it had already hardened into a thing his mother referred to in a particular way. She said, "Since you went away for 11 years, not since you moved." since you went away, which is a sentence about her. The first Christmas I went up was 2008, and I want to describe it because everything about the next decade is in it. Camilla had a list. It was on the kitchen wall on a clipboard, and it had the 4 days broken into segments, and every segment had a thing in it, and the things were all lovely: a walk, a particular pub, a market, a film, and there were 19 of them across 96 hours. I said at some point on the second day that we might have a lie-in, and there was a pause of about 4 seconds, and then she laughed and said, "Of course. Whatever you like," and then the entire rest of that day was slightly wrong in a way I could not point at. Toby explained it to me on the way home. He said, "The list isn't a plan. The list is proof that we came." I said I did not understand. And he said, if we do 19 things in 4 days, then when we leave she can look at the list and know it happened. If we just sit around, we might as well not have been there. That is the whole of Camilla Rook in one clipboard, and I understood it in 2008, and then spent 17 years failing to act on it. The tension over the 11 years of my marriage was constant and low grade, and never once became a row. It ran on a single mechanism, which I could describe in my sleep by 2015. Camilla would express a hope, at length, in a way that placed the responsibility for its fulfillment entirely on somebody else, and then absorb the outcome with visible grace, whatever it was. We would go up for 4 days. She would hope aloud on day 1 that we might manage 5 next time. Toby would ring on a Sunday. She would say how lovely it was and how she never wanted to bother us. We had Imogen in 2014, and at the hospital, 11 hours after the birth, Camilla said on the phone that she did not want to intrude and would wait until we asked, and then rang every day for 9 days to check whether we were ready to ask. None of that is monstrous. Every individual instance is a lonely woman being slightly too much, and any reasonable person absorbs it. The problem is that 11 years of absorbing it turned my husband into a man who managed his mother, and I married the management along with him. The autumn of 2018 was worse, and I did not clock how much worse until afterwards. Camilla had had a bad year. Her sister had been ill in the spring. She had turned 64 in the June and had been strange about it in a way that surprised me because she had been fine at 60. And she had started, from about the August, to raise moving. Not asking us to move. She never asked. She raised it. A bungalow near her had come up. A nice one, she happened to know the family. The schools that way were meant to be very good. Wasn't it a shame that Imogen would grow up without knowing the place her father grew up in? Toby dealt with all of it by not passing it on. I found out how much of it there had been only after he died, when his sister-in-law, Camilla's sister's daughter, mentioned in passing that Camilla had been talking about the bungalow since June. June, 5 months of it, and my husband had brought me perhaps 2 mentions. He was protecting me from it, which sounds kind and which meant that when he got in a car on the 8th of November, I had no idea he was walking into the 11th round of an argument that had been running since the summer. I thought he was going up for a normal weekend. I said, "Say hello to your mum," when he left, and that was the last thing I ever said to him in person, and it is a perfectly nice sentence, and I have never once been comforted by it. I want to set down exactly what I have and do not have about that night, because I have been accused, in my own head at 2 in the morning, of building a case out of very little. What I have, a 4-minute and 11-second call at 10:31 p.m. My memory of it, which is extremely clear because I have not been allowed to discuss it with anybody for 7 years, and so it has never been eroded by retelling. His words about what she said, which I am confident of to within about 4 words. What I do not have, any evidence at all, no recording, no text, no witness. Camilla has never mentioned that conversation, and I have never asked. I am aware that if I put it in front of somebody, they could say, "A tired man drove home at night on a wet road and misjudged a bend that has killed 3 people, and his wife has attached a phone call to it because grief needs a reason." That is a completely reasonable thing to say, and I have said it to myself perhaps 400 times at 4 in the morning. Here is what I have landed on, and I have had 7 years. I do not think she caused it. I want to be very clear about that, because it is the difference between what I have carried and what I would be accusing her of. I think a bend on a wet road at 11 at night caused it. I think if he had left at 10 past 10 or half past 11, he would probably be alive. And I think the reason he left at 20 past 10 instead of staying the night, as he had stayed the night on every previous visit for 11 years, is that his mother told him that if he really loved her, he would move back. That is not causation. That is not something anybody could put in front of a coroner, and it is not something I would want to. It is simply the reason he was on that road at that minute, and I am the only living person who knows it, and I have never been able to decide whether that is a burden or just a fact. The thing that started it was a haircut. I want that recorded plainly because when people ask what caused a grandmother to take her daughter-in-law to court, they expect a rupture, and there was not one. There was a haircut in August. Imogen was 10 and a half and she wanted it short. Not a bob. Short, above the ear on one side, which is a thing 11-year-olds have wanted since about 2021 and which I had no feelings about whatsoever. She had it done on a Saturday, and she was so pleased with herself that she could not stop looking in shop windows on the way home, and she rang Camilla that evening to tell her, off her own bat, without being asked, which is the entire point of what happened next. Camilla went quiet on the phone. Imogen told me afterwards. And then Camilla rang me at 10 past 9, after Imogen had gone up, and said, "I'm not going to make a thing of it." I said, okay. I just think, at her age, with everything, she needs to feel like a girl. I said something short and not unkind. And then Camilla said the sentence that I now understand was the beginning of 11 months of legal proceedings. Toby would have hated it. I did not react well, and I want to own that, because I have spent a lot of this account being reasonable, and in that one phone call I was not. I said, "You have no idea what Toby would have thought." Silence. And I said, he'd have taken a photo and sent it to everybody he knew, and he'd have been unbearable about it for a fortnight. Which is true. Which is exactly, precisely what he would have done, and which is a thing I know and she does not, because he was my husband for 11 years and her son for 36, and those are not the same access. She said, "Well, you knew him better than I did, apparently, in the voice," and I said, "In some ways, yes," and there was a silence of about 4 seconds, and then she said she had to go. That was the 16th of August. The petition was filed on the 11th of February. 6 months, almost to the day. In between, there were 3 things, and I did not see any of them for what they were. In September, she did not come for Imogen's birthday. She had a chest thing. It was probably real. She is 71 and she does get chest things. In October, she rang me and asked, in a slightly formal way that I noticed and did not think about, how often Imogen saw her father's side of the family. And in November, on the 8th, when I rang her as I have rung her every year, she was strange with me for about 20 minutes and then said, out of nowhere, "Do you ever think about moving back up here?" I said no, honestly, because Imogen's school is here, and my job is here, and my mother is here. And Camilla said no, of course. And then, in December, she did not come for Christmas. That was the first genuinely alarming thing, because she has come for Christmas every year since 2018, and she canceled on the 19th by text, which is not a thing she does, and the text said, "I think it's better this year. Give Imogen my love and tell her the parcel is in the post." Imogen cried. Not immediately, she is not a crier. She was fine on the day, and then on the 27th she came and stood in the kitchen doorway and said, "Is Granny cross with us?" And I said no, absolutely not. She has a chest thing and she is 71, and January is hard for old people. That is the 3rd lie in this account, and it is the one I regret. Not the enormous one about the phone call, which I would tell again. That small managing one to an 11-year-old in a kitchen doorway, which I told because it was easier than saying I do not know, and which taught my daughter that when something is wrong in this family, the adults produce a reason. The petition arrived on the 11th of February, and I read it properly at 11 that night after Imogen was asleep, at the kitchen table, with a glass of wine I did not drink. It was 11 pages, and it was, I have to say this, extremely well done. There was no accusation of neglect, nothing about drinking or drugs or men or the house. If there had been, I could have gone into a courtroom and demolished it in an afternoon, because none of it would have been true. What it said instead was this: that since her son's death, the petitioner had maintained a close and continuous relationship with her granddaughter, which was true. That over the preceding 12 months, the respondent had progressively reduced contact between the petitioner and the child, which was false but not provably false, because contact had reduced, and every reduction had been Camilla's own cancellation, and cancellations do not leave a record. That the respondent had made unilateral decisions regarding the child's appearance and presentation without consultation with the paternal family. The haircut, in a legal document, in paragraph 9. And that the respondent presented as volatile, and that this had been observed by the petitioner in a telephone call on the 16th of August, in which the respondent had become hostile regarding the child's late father. That is the one, that is the paragraph that kept me up. Because I did become hostile in that phone call. I said, "You have no idea what Toby would have thought." I said it sharply, and I meant it to land. Every fact she had given her lawyer was true. She had simply removed the sentence before it. I got a solicitor in the 3rd week of February, and she was, thank God, the right one first time, which I know is unusual. Diley's Bramall is about 60, does family work, has a first-floor office above an estate agent, and a manner that I can only describe as unhurried in a way that makes you slow down too. She read the 11 pages twice while I sat there. Then she took her glasses off and said, "Right. First, this is not a custody case. Nobody is trying to take your daughter. I want you to hear that clearly because you have been carrying it around for a fortnight as though somebody is." I burst into tears, which I had not done at any point in the fortnight. Second, Diley said, when I had finished, "This will be decided on one question, and it is not whether you are volatile. It is whether contact with the grandmother is in the child's best interests. That is the whole test. Everything in these 11 pages is scenery. So we win." "Probably," she said, "and you will hate every minute of it, and it will take somewhere between 9 and 14 months, and I want to tell you now what it is going to cost, because it is not money." She was right about the cost, and I did not understand it in February. What a grandparent visitation case costs is this: a stranger comes and asks your child questions about you. The court appoints somebody. In our case, a guardian, a man called Gareth Price, whose job is to represent Imogen's interests independently of me, and independently of Camilla, and independently of the court. He interviews the child, alone, more than once. He asks her about her home and her mother and her grandmother and what she wants, and he writes a report, and that report is, in practical terms, the case. And there is a rule about it that Diley's explained to me in the first meeting and repeated in every single meeting afterward, and which is the entire spine of this story. You must not discuss it with her. Not the case, not the petition, not the word volatile. You may not prepare her, you may not explain your side, you may not tell her what her grandmother has said about you. If the guardian forms the view that the child has been influenced, that finding will do more damage to your position than anything in the 11 pages. So my daughter, I said, is going to be interviewed about whether I am a good mother, and I am not allowed to tell her that she is going to be interviewed about whether I am a good mother. You may tell her a man is coming to talk to her about the family, and that she should say whatever is true, Diley said. That is the entire permitted script. And Mrs. Rook, I have done this for 31 years, and I am going to tell you the thing that clients find hardest to believe. Go on. The parents who lose these, she said, almost never lose them on the facts. They lose them because they could not stop themselves explaining. I have moved through the first 4 years too fast, and they are where the actual damage was done, so I am going back. November 2018. Imogen is 4 years and 2 months. I am 34. I have a job I have been in for 11 months and a mortgage that assumed 2 incomes. The first year is a fog, and I remember about 6 days of it. I remember the 8th of January, 2 months after, standing in the kitchen at 6 in the morning, realizing that I had not eaten a meal sitting down since the funeral. I remember the first time Imogen said, "When Daddy comes back," and the specific way my whole body went cold. And then the second time, 4 days later, when she said it experimentally, watching my face, testing what it did. And I remember the letter from the coroner's office confirming the inquest date, and reading the phrase "no third-party involvement," and sitting on the stairs. Camilla came for 3 weeks in the December, and it was the worst 3 weeks of my life, and it is the origin of everything that happened afterward. I want to be fair to her about those 3 weeks. She had lost her only child 11 days before she arrived. She was 64. Her husband had died in 2011. Toby was, in the completely literal sense, the entire remaining content of her family. And she was extraordinary with Imogen. I have never said otherwise, and I am not going to start. She got down on the floor. She did voices. She took her to the park every single afternoon of those 3 weeks, in December in the cold, because it got her out of a house full of adults crying. My daughter's clearest memories of the winter her father died are of her grandmother, and they are good. And that is Camilla's doing, and I will be grateful for it as long as I live. And she also, in those 3 weeks, went through my kitchen cupboards and reorganized them. She rewashed washing I had already done. She said, 4 times, in front of other people, "Well, Neve's coping marvelously," in a tone that made every single person in the room look at me to check. And on the 19th of December, she stood in my hallway and said, "I think Imogen should come to me for a while, just until you're back on your feet." That is the sentence. If this story has a beginning that is not the Fenwick Road, it is that sentence in a hallway on the 19th of December 2018. I said no. I said it politely, and she said, of course. It was only a thought, and she never raised it again in 7 years. And from that day, I have never once been able to be in a room with Camilla Rook and not be, at some level, presenting evidence. That is what she never understood, and what I did not understand either until a corridor in November. She thinks I shut her out because I did not like her. I shut her out because on the 19th of December 2018, she suggested taking my daughter, 11 days after I lost my husband. And from that moment, every casserole and every reorganized cupboard and every well-meant remark about coping marvelously was, to me, part of an assessment. She was not assessing me. I am about 90% sure of that now. She was a woman who had lost everything and who reached for the one thing she thought she could still be useful for. But I have spent 7 years being watched by somebody who was not watching me, and the exhaustion of that is not smaller because it was imaginary. The 4 years between 2019 and 2023 are the ones people skip, and they are where the pattern set. What happened in those years is that I built a system. 8 visits a year, on dates I chose, trains I booked, a phone call on Sundays at 6 that I initiated and then left, a present at Christmas and a present in September that I bought and wrapped and labeled from Imogen, a phone call on the 8th of November that I made every year before she could make it. Every single element of that system had 2 functions, and I only admitted the first one to myself. The first function was that Imogen had a grandmother. That was real, and it mattered, and I would do it again. The second function was that the system meant I never had to have an unstructured conversation with Camilla Rook for the rest of my life. A booked train has a time on it. A Sunday call has a child in the middle of it. A present has a label. Every single thing I built was a piece of scaffolding that let contact happen without contact, and I built it in the first 18 months and then maintained it for 5.5 years, and I told myself the whole time that I was being generous. Diles said something in the July, after the Guardian's report came, that I did not want to hear. She said, "You have run a 7-year contact arrangement with total reliability and no warmth, and if we get a difficult judge, that is going to be visible." I said that was not fair. And Diles Bramall, who is 60 and does not soften things, said, "It is not a criticism, Mrs. Rook. Reliability is what the court measures. I am telling you that you did the measurable thing perfectly and the unmeasurable thing not at all, and that you should know that about yourself before somebody else tells you in a witness box. There is one more thing from those years, and it is the one that makes me least comfortable. In the summer of 2021, Imogen was 6, and she came back from her week at Camilla's, and at some point in the car she said, "Granny cries in the kitchen." I said, "Does she?" And Imogen said in the morning, "She thinks I'm asleep. She's not sad about it though, she's fine after." I said something reassuring about how grown-ups are sad about Daddy too, and my daughter accepted it, and we listened to the radio for the rest of the way home. And I did not ring Camilla. I did not ring her that night or that week or that year. A woman 210 miles away was crying alone in her kitchen at 6 in the morning. Every day of the week my daughter was there. And I knew it from the July of 2021, and I did nothing with it for 4 years. I told myself she would not want me to know. That is probably even true. But the honest version is that ringing her would have required a conversation with no scaffolding in it, and I had built the entire architecture of 7 years specifically to avoid one, and I was not going to dismantle it for something I could file under privacy. When she said in that corridor that she had been trying to ring me for 7 years, I thought about the kitchen in 2021, and that is the reason I did not defend myself. I told Imogen on a Sunday afternoon in March, in the car, because everything difficult in our house happens in the car, where nobody has to look at anybody. I said, "Granny would like to see you more, and she has asked a court to help sort it out, and that means a man called Gareth is going to come and talk to you about our family, and you should tell him whatever is true." She was quiet for about a mile. Then she said, "Is Granny suing you?" I said, "No, she's asking a judge to make a plan." "Is that the same as suing you?" And I said, "A bit, because she was 11 and not stupid, and because I had already decided that whatever else happened in the next year, I was not going to be a parent who produced reasons." She looked out of the window for another mile, and then she said, "Why didn't she just ask?" That is the question, and I did not have an answer for it in March. I have one now, and it took 11 months and a conversation in a corridor to get it. And I will put it here because otherwise you will spend this whole account thinking Camilla was simply cruel. She did not ask because asking can be refused. That is the whole of it. A woman whose organizing terror is being left cannot make a request because a request creates the possibility of no, and the possibility of no is the thing she has spent 71 years constructing her entire personality to avoid. A petition cannot be refused. It can be resisted, defended, argued about, but it cannot be ignored, and the person on the other end of it must engage. Camilla Rook did not go to court to win access to her granddaughter. She went to court because it was the only mechanism she could think of that guaranteed she could not be left. I did not know that in March. In March, I thought she was punishing me for a haircut. The 11 months are mostly waiting, and I am not going to pretend they were dramatic. There was a first directions hearing in April, which I attended, and which lasted 19 minutes, and at which nothing happened except dates. Camilla was there. First time I had seen her since Christmas of the year before. She was in the good Navy coat. She had come 2 hours and 10 minutes on the train. She sat on the other side of the corridor with her solicitor and her handbag on her knees with both hands on it, and she looked so small that something in my chest did a thing I had spent 2 months making sure it would not do. At one point, her solicitor went off to find someone, and we were alone in a corridor for about 90 seconds. She said, "How is she?" And I said, "She's well. She's got a part in the play." And Camilla said, "Which one?" "Some kind of narrator. She has to memorize about 400 lines, and she is insufferable about it." And my mother-in-law laughed. Genuinely, briefly, the laugh that makes strangers look over. And then she remembered where we were and stopped and looked at the floor, and I said nothing, and her solicitor came back. Gareth Price came to the house on the 22nd of May. He is about 50, soft-spoken, and he had been doing this for 19 years, and I want to say clearly that he was completely fair, and I have no complaint about him at all. He was in the house for 3 hours. He spoke to me for about 40 minutes, and then he asked me to go out, and I walked round the block for an hour and 10 minutes in the rain while a stranger sat in my kitchen with my daughter. That hour is the worst thing that happened to me in the whole 11 months, and it is the thing nobody understands unless they have done it. Because there is nothing you can do. There is no preparation, no reassurance, no way to be present. You have handed an 11-year-old the entire question of your adequacy as a mother and gone out in the rain, and the only thing you have going for you is 7 years of choices you made when nobody was assessing you. I walked past the same postbox 4 times. At one point I sat on a wall. And the whole way round, on a loop, the thing I could not stop thinking was, I could have told her. Not coached her, just told her. About the phone call at 10:30. About the argument. About the fact that her grandmother, who was now describing me as volatile in a legal document, had said something to Toby that put him on the Fenwick Road at 11 at night. One sentence to an 11-year-old and the case would be over, because a guardian who hears that from a child does not write a report recommending increased contact. I had it. I had had it for 7 years. It was completely true, and I could prove none of it, and I did not need to prove it, because the guardian was not a court and Imogen was not a witness, and the damage would have been done the moment she heard it. I walked past the postbox a 4th time and did not do it, and that hour is the single thing in my life I am proudest of, and nobody has ever congratulated me for it, because nobody except Diley's Bramall knows it happened. Gareth's report came in July, and it was 11 pages, which seems to be the length of everything in this story. I am not going to quote from it, because it is about a child. I will say that it recommended contact broadly at the level that had existed in 2022 and 2023, 8 or 9 occasions a year, a week in summer, the Sunday phone call, which is to say, it recommended precisely what I had been organizing, unpaid and unthanked, for 7 years. And there was one paragraph, in the middle, that I have read perhaps 200 times. It said that the child spoke about her grandmother warmly, spontaneously and at length, that she was able to describe recent and specific shared activities, that she expressed no anxiety about contact and some sadness about its reduction, and that the guardian observed no indication whatsoever that the child had been exposed to adult conflict or to negative characterization of the paternal family. No indication whatsoever. 7 years. 8 visits a year I arranged, a phone call every Sunday I made sure happened, a birthday present I wrapped and labeled in my left hand, and one enormous true sentence I did not say. And the entire case turned on a paragraph confirming that my daughter loved her grandmother, which was the thing I had been protecting since she was 4 years old, at my own cost, in silence, for reasons that had nothing whatsoever to do with a court that did not exist yet. Diley's rang me the day the report came and said, "You understand what has happened here?" I said not really. And she said, her case was that you were alienating the child from the paternal family. The only evidence that could ever have settled that question is the child's own relationship with her grandmother. And you spent 7 years building the exact thing that disproves it, without knowing you would ever need to. She let that sit. I have done this for 31 years, Diley's Bramall said, and I have never once seen a parent in your position who had not, somewhere along the way, said something. Not coaching. Just one bitter sentence in a kitchen, 18 months earlier, that the child repeats to a guardian without understanding what it is. I nearly did. When? In May, walking round the block. And Diley said, yes, that is when everybody does. I have not said anything about what the 11 months cost, and it should be here, because people who have not been through a family court matter imagine it as a series of dramatic days, and it is almost entirely the opposite. It cost £11,400. I had 8,000. The rest came off a credit card and took 19 months to clear. It cost, by my count, 14 days of annual leave, none of them spent on anything except hearings, meetings with Dileys, and one day in June when a bundle had to be filed and I could not do it from work. And it cost me the ability to be casual in my own house, which is the one nobody warns you about. From February to November, I could not have an ordinary bad day. If I snapped at Imogen about the state of her room, which any mother of an 11-year-old does about 4 times a week, there was a voice underneath it saying, "That is what volatile looks like from the outside." I stopped raising my voice entirely, not out of virtue, out of evidence management in my own kitchen with my own child for 9 months. She noticed, obviously. Children notice everything. In about the July, she said, "You've gone weird." I said, "Weird how?" And Imogen said, "You're being really nice." That is the sentence that I would put in front of anybody who thinks a grandparent case is a minor procedural thing. An 11-year-old telling her mother she has gone weird because she is being really nice. Because what she was describing, exactly and accurately, was that the ordinary friction of a house had been removed and replaced by a woman performing suitability. And a child does not experience that as warmth. She experiences it as her mother being replaced by a slightly better behaved stranger who will not tell her off about the towels. I did not correct it because I could not explain it, because Dialy's had told me in February that I could not discuss the case with her, and I had taken that instruction absolutely literally for 5 months. I want to say to anybody in the middle of one of these, the instruction is do not discuss the case. It is not do not be yourself. I lost about 4 months of ordinary life with my daughter because I could not tell the difference, and nobody, including Dialy's, thought to tell me. The other cost was Bree, and it is the one I did not see coming at all. My sister is 2 years younger, and she was the person who came the night Toby died, and she slept on my sofa for 6 weeks in 2018, and she is, by an enormous margin, the most important adult relationship in my life. And from about April, she started to be careful with me. I noticed it in May, small things. She stopped telling me about problems with her own children. She started asking how I was in a particular voice. And in the July, I asked her directly, because I have learned that with Bree you have to, and she said, "I don't want to add to it." I said, "Add to what?" And my sister said, "Neve, you've been a bit much since February. I want to record that I did not handle it well." I said something sharp about how sorry I was that my mother-in-law suing me was inconvenient for her. And Bree said, completely evenly, "That is exactly what I mean." She was right. I had become a person with a single subject. Every conversation I had between February and August with anybody arrived at the case within about 4 minutes, and I did not notice because from the inside it did not feel like a subject. It felt like the weather. We were all right by the September. It took an apology from me and about 6 weeks. But there was a stretch in the middle of that year when I was, effectively, alone with it, and I did that to myself. The nights are the thing I remember most clearly, and they were all the same. Imogen went up at 9. I would do the kitchen, and then I would sit down at the table with the bundle, which by August was 11 centimeters thick in a lever arch file, and I would read documents I had read 40 times. I was not looking for anything. That is the strange part. I had read all of it. Dialy's had read all of it. There was nothing in that file that a 5th reading was going to produce. I read it because reading it felt like doing something, and because the alternative was going upstairs at 9:30 and lying in the dark. There is a specific kind of insomnia that comes with being accused of something. It is not anxiety exactly. It is that your brain runs a courtroom at 2 in the morning in which you are extremely eloquent and everybody understands, and it runs it 4 or 5 times, and each time it is a little less convincing, and by 4 you have talked yourself into the possibility that they might be right. That is what happened to me in about the June. 4 in the morning on a Tuesday, and I thought, with complete clarity, what if I am volatile? I got up and made tea and sat on the stairs and went through it. And what I found at the bottom of it was that I could not actually tell anymore, because for 4 months every ordinary human reaction I had was being run through a filter that asked how it would look in a report. You cannot examine your own temperament while being assessed on it. The assessment changes the thing, and the longer it goes on, the less access you have to what you were actually like before somebody wrote a word in a document. That, more than the money and more than the leave, is what those 11 months took. For about half a year, I lost my own opinion of myself, and had to take it on trust from other people, and the people I most wanted it from were the ones I could not discuss it with. Kemi Ademi is the reason I got through the middle of it, and she has not appeared in this account yet because she was not involved in any of it, which is precisely the point. She has been my closest friend since we trained together in 2009, and she works in a hospital trust 200 miles away, and we speak on Thursdays. In about the May, without ever announcing it, she stopped asking about the case. She rang every Thursday for 9 months and talked about her sister's wedding, and a colleague she loathes, and a series she was watching that she made me start so we could argue about it. And every so often she would say, "And how's the thing?" and I would say, "Still going," and she would say, "Right," and move on. I asked her about it afterwards. I said, "Did you do that on purpose?" And Kemi said, "Obviously. You had a solicitor for the case. You didn't have anybody for the rest of your life." That is the single most useful thing anybody did for me in that year, and it consisted entirely of a woman deciding, on her own, without being asked, to be the one place where the case did not exist. It should have ended in July, and it did not, and the 4 months after the report are the part of this I understand least about myself. Camilla did not withdraw. Her solicitor sought a further hearing. The grounds were that the guardian's recommendation did not adequately reflect the petitioner's role prior to 2024, and that a defined order was necessary because informal arrangements had proved unreliable. Informal arrangements had proved unreliable, meaning Neve organizes everything and I want it written down so she cannot stop. Which, if you take the 7 years out of it, is not an unreasonable thing for a 71-year-old woman to want. And which, with the 7 years in it, was the most insulting document I have ever been handed. I lost my temper exactly once in 11 months, and it was in August, and it was not at Camilla. It was at my sister Bree, in my own garden at a barbecue in front of 4 people. She said something completely harmless. She said, "Honestly, Neve, just give her the order. It's the same amount of contact. What difference does it make?" And I heard myself say, at volume, because I have spent 7 years doing it for free and now she wants a judge to make me do it and call it her win. And then, into a silence in a garden with 4 people in it and a paper plate in my hand, I said the other thing. I said, "And she doesn't get to be the one who wants more of him." Nobody knew what I meant. Bree still does not know what I meant. She thinks I meant that Camilla was claiming a larger share of Toby's memory, which is a reasonable interpretation and which is about 4% of it. What I meant was, she does not get to stand in a courtroom and present herself as the one who has been kept from him, when she is the reason he was on that road. I went inside and stood in the utility room for about 11 minutes. That is the closest I came in the entire year, not the walk round the block, a barbecue in August with a paper plate. The final hearing was on the 4th of November, 4 days before the 7th anniversary, which nobody had planned and which everybody noticed. It took a day. Diles had told me it would take a day, and I had not believed her. I thought these things took an hour. Camilla gave evidence for about 80 minutes. And I want to describe this carefully, because it is the moment the whole thing turned, and it had nothing to do with anything I did. She was good at first. She was warm and precise, and she cried in the right place, which I am not being cynical about. She was crying about her son, and it was real. And then Diles stood up and asked her 9 questions. I have read the transcript since. 9 questions, over about 11 minutes, none of them raised voices, and Diles Bramall did not once suggest that Camilla Rook was a liar. She asked when the petitioner had last arranged a visit herself, rather than accepting one that had been offered. Camilla said she did not understand the question. Diles rephrased it. In the 7 years since her son's death, could the petitioner identify a single occasion on which she had initiated, organized, booked, or paid for a contact arrangement? There was a pause of, according to the transcript, 11 seconds. Camilla said, "Neve always did it." Diles said, "Yes, thank you. And in September 2024, October 2024, and December 2024, who canceled?" I was unwell. Of course, and who canceled? I did. And in the 12 months described in paragraph 4 of your petition as a period in which contact was progressively reduced by the respondent. How many of the canceled arrangements were canceled by the respondent? Another pause. None, Camilla said. She did not do it cruelly. That is what I keep telling people who want this to be a demolition. Diles asked 9 factual questions in a level voice, and every single answer came out of Camilla's own mouth. And by the 9th one, it was completely clear to everybody in that room, including the judge and including Camilla, that the woman who had petitioned about reduced contact was the woman who had reduced it. And then Diles sat down without making a speech about it, which I did not understand at the time, and which she explained afterwards. She said, "Never explain the point you have just made. If you explain it, you have made an argument, and an argument can be disagreed with. If you sit down in silence, the judge makes it himself, and a judge does not disagree with himself." The judge asked me 4 questions, and I have thought about the second one every week since. He asked whether I had any objection in principle to the child spending time with her paternal grandmother. I said no, none at all. He asked why. In that case, I was resisting an order. And I had a prepared answer, which Diles had drafted with me, and which was about flexibility and the child's changing commitments and the impracticality of fixed dates across a 2-hour distance, and it was a good answer. I did not give it. I said, because I have arranged all of it for 7 years and nobody has ever once asked me to. And if you make an order, then from Friday I will be doing it because a court told me to, and I will have to live the rest of my life knowing that the reason my daughter has a grandmother is a piece of paper, and not the fact that I drove her 2 hours and 10 minutes every school holiday when I did not want to. The judge wrote something down. Then he said, "Mrs. Rook, do you want her to have a grandmother?" And I said, "Yes, very much. That is the entire problem." He gave a short judgment at the end of the afternoon, and it did not go the way either of us expected. He declined to make the order Camilla sought. He said the evidence did not support a finding that contact had been obstructed, and that the guardian's report described a warm and functioning relationship, which the court should be extremely slow to formalize, because formalizing a working relationship tends to damage it. Then he said a thing that was not in anybody's submissions, and I have the transcript, and I have read this paragraph more than anything else in the whole file. He said that he had been struck, in a case of this kind, by the almost complete absence of hostility in the evidence about the child. That in 19 years, he had rarely seen a guardian's report in a contested application record no negative characterization of one adult party by the other. And that whatever the parties' difficulties, both of them appeared to have kept the child out of it, and that this was to the considerable credit of both. To the considerable credit of both. I sat in that courtroom and had, in front of my mother-in-law and a judge and Diles Bramall and a man from the court office, the single most complicated feeling of my adult life. Because he was right about her. She had never once in 7 years said a word against me to Imogen. Not one. Gareth's report established that as clearly as it established the reverse. Camilla Rook had taken me to court and called me volatile in a legal document, and had spent 7 years being scrupulously careful never to let my daughter hear a word against me. Both of those are true. I have had to hold both of them ever since. I want to put down what Imogen was actually like through it, because she is the only person in this account who behaved well the whole way through, and she was 11. She knew more than I told her. Obviously, children in a house where something is happening always know the shape of it even when they do not know the content. What she did with that, over 11 months, was to become extremely and unnervingly practical. In the April, she asked me how much a solicitor costs. I said a lot. She said, like a holiday or like a car. I said between the two, and she said, right, and went back to her tablet, and 3 days later she told me she did not need new football boots this season because hers were fine. They were not fine. They were a size too small, and I found out in the June. That is what an 11-year-old does with a thing she has half understood. She does not ask questions. She quietly reduces her own footprint, because she has worked out that the household is under strain and the only lever she has is herself. I have talked to her about that since, at 14, properly, and she has no memory of doing it. She remembers the boots being small. She does not remember deciding. The Guardian interview, from her side, I only got about 18 months later. She told me in the car, everything difficult in our family happens in the car, when she was 12 and a half, apropos of nothing. She said, that man who came, Gareth, he asked me if you ever say bad things about Granny. I said, and what did you say? And Imogen said, I said no. And he asked again in a different way, and I said no again. And then he said, does your Granny ever say bad things about your mum? And I said no. Then she said, and then he asked what happens if you two disagree about something, and I said I don't know because I've never seen it. I had to concentrate quite hard on the road. Because that is exactly right. In 7 years, my daughter had never once seen her mother and her grandmother disagree about anything, because in 7 years, I had constructed a system in which we were never in an unstructured room together long enough for a disagreement to be possible. The thing that won the case was the thing that was wrong with our family, both at once from the same cause. I have never been able to separate them, and I have stopped trying. There is one part of the Guardian's report I have not mentioned, and it is the part that hurt. There was a paragraph about me. It was not critical. It said the respondent presented as organized, articulate, and highly capable, and that she described the contact arrangements in detail and with evident pride in their consistency. Evident pride in their consistency. He was not being unkind. He was recording, accurately, that a woman had spent 40 minutes describing a 7-year logistics operation, and that the thing she was proudest of was that it had never failed. I read that paragraph in July, and put the report down and went and stood in the garden. Because he had put his finger, without meaning to and without knowing anything about the Fenwick Road, on the exact deformity. I had turned a relationship into an operation and then become proud of the operation, and a stranger had spent 40 minutes with me and heard it in my voice. I asked Diles, in the September, whether I should be worried about that paragraph. And she said no, and then she said, but you should probably be worried about it in about 4 years, when Imogen is 15, and she is the one deciding whether to ring. I said, what does that mean? And Diles Bramall said, it means the operation has an expiry date. You have run that relationship on your daughter's behalf since she was 4. In about 4 years, she will run it herself, and what she will have to go on is whatever she has seen you do. And what she has seen you do is book trains. That conversation is why the December phone call happened. Not the corridor. People assume the corridor changed me, and it did not. It broke something open, but I could have closed it again by the following Tuesday, and I very nearly did. What made me ring on the 14th of December and stay in the room was a solicitor saying, in an office above an estate agent, that my daughter would one day inherit a template. Imogen is 14 now. She rings her grandmother on Sundays. Sometimes I am in the room and sometimes I am not, and there is no longer any pattern to it, which is the entire achievement. And in the October just gone, she asked whether Granny could come for Christmas, and I said yes, and Imogen said, can I ask her? Not you, me. And I said yes. She rang her that evening on her own, from her room with the door shut, and came down 40 minutes later and said, she's coming on the 22nd. She's getting the 9:10, and she said don't do a fuss. Which is the whole thing, right there. A 14-year-old organizing her own grandmother. 7 years I ran that operation, and it turned out the handover took one phone call from somebody who had never been taught to be careful. Camilla was 73 last month, and she is fine and she is not fine, in the way that people of 73 are. There is a thing with her memory now, not dementia. She has been assessed, and it is not that. It is ordinary and age-related, and it means she repeats herself on the phone about twice in 50 minutes, and I let her, and I have got quite good at hearing a story for the 4th time. What frightens me is a different thing entirely, and I have not said it to anybody, and I am going to put it here because this account has been honest about everything else. She is going to forget the argument. That is a real possibility now. There will be a point, maybe 5 years, maybe 15, when Camilla Rook no longer remembers what she said to her son on the 8th of November 2018, and by then, I will be the only person on this earth who knows it happened at all. And on that day, the thing I have been carrying stops being a secret I am keeping from her, and becomes a fact that exists nowhere except inside me. I do not know what I am supposed to do with that. I have raised it once with the therapist, and she said something reasonable about how the purpose of holding it was never storage, and I have thought about it for a year and I still do not know. Toby made a decision in a car on a wet road at 10:30 at night, not to say a thing he could not take back. He died 11 minutes later, and that decision became permanent, and I have spent 7 years enforcing it on his behalf. At some point, his mother will forget the sentence he was protecting her from, and I will still be enforcing it, alone, about a thing that no longer exists in the world. I think I will keep doing it anyway. I think that is what it is to be the person who was in the room. The corridor afterwards is the actual end of this story, and everything else is aftermath. I was putting my coat on. Diley's had gone to speak to the clerk. Camilla's solicitor had gone ahead to the lift. And Camilla came and stood in front of me, in the navy coat, with a handbag, and she was shaking. She said, I didn't mean volatile. I said nothing. That was his word, the solicitor's. He asked me for examples, and I told him about the telephone call in August, and he wrote volatile, and I read it, and I signed it. She was looking at my collar and not my face. I have thought about that word every night since February. And I said, you could have rung me. And Camilla Rook said, I have been trying to ring you for 7 years. I want to be precise about what happened next because it was 11 seconds long, and it changed the whole of the rest of my life. I said, you ring every Sunday. And she said, I ring Imogen. And then she said, you put her on and you go out of the room every week for 7 years. I have never once had a conversation with you that wasn't about a train time. I stood in a corridor with my coat half on. Because it was true. It was completely, entirely, verifiably true, and I had never noticed it, not once, in 364 Sunday phone calls. I had organized everything. The visits, the trains, the presents, the birthday, the 8th of November. And I had done every single piece of it as an administrator, a facilitator, a person handing a child to a grandmother and stepping out, and in 7 years I had not had one conversation with that woman about anything at all. I thought I had been protecting her. What I had actually been doing, from about the 4th month, was managing her. There is a difference, and it is enormous, and it took me until a corridor in November to see it. You protect somebody by keeping something from them. You manage somebody by keeping yourself from them. I had done both. I had told myself the first one was the reason for the second one, for 7 years, and it was not. The secret was the reason I could not be in a room with her. Every time I looked at Camilla Rook, I saw the Fenwick Road, and I could not stand it, so I handed her a telephone and left. She said one more thing, and then her solicitor called her from the lift. She said, I thought if a judge told you to, you'd have to. Have to what? I said. And Camilla said, let me in. I did not tell her. Not that day, not in the corridor, not in the 11 months since. I want to be extremely clear about that, because a version of this story ends with a reconciliation in which everything is said, and that is not what happened, and I do not think it should have. I have thought about it properly over about a year, with a therapist and with Diley's, who is not my therapist and who told me to stop discussing it with her at the same hourly rate. And what I have decided is this. Telling her would not be honesty. It would be a transfer. I would be moving 7 years of weight off my chest and onto a woman of 72 who has nothing to do with the rest of her life except think, and who would then be alone in a bungalow 210 miles away with the knowledge that the last thing she said to her son sent him out into the rain. That is not a truth she needs. It is a truth I want to put down. There is a version of me that believes she is entitled to it because it is about her own life. I take that seriously. It kept me up for most of the January after the hearing. But I keep landing in the same place. He did not want her to know. That is why he rang me from the car instead of going back inside. The last decision my husband made was to drive home rather than say a thing he could not take back. And if I say it for him 7 years later, then his last decision was for nothing. So I hold it. I have held it since I was 34, and I will hold it until one of us dies. And if it is me first, then it goes with me. And I have written instructions to that effect in with my will, which sounds insane and which I have done anyway. What I did instead was ring her on a Sunday in December at 6 o'clock, and when Imogen finished, I did not go out of the room. I said, "Camilla, it's me. Have you got 10 minutes?" There was a silence on that line that went on so long I thought she had gone. And then my mother-in-law said, in a voice I had never heard, "Yes." We talked for 51 minutes, about nothing. About the play Imogen was in, and about her neighbor's dog, and about whether the boiler people were robbing her, which they were. At the end, she said, "Same time next week." And I said yes. That was 22 months ago, and we have not missed one. We do not talk about the case. Once, in the March, she started to, and I said, "Camilla, I would rather not," and she said no. No, all right, and we have not since. We do not talk about Toby much either, which surprises people. Perhaps 11 times in 22 months, and always at her instigation, and I let her lead it because it is the one area where I am not able to be honest, and I have decided that the least I can do is not steer. What we talk about is entirely trivial, and there is roughly 50 minutes of it every Sunday, and I would not give it up now for anything. Bree asked me last year whether I had forgiven her, and I said the true thing, which is that forgiveness has not really come into it, because the thing I am doing on a Sunday evening is not forgiveness. It is repair of a specific fault I introduced in 2018 when I started handing over a telephone and leaving a room. She took me to court. That happened, and it was ugly, and it cost me £11,000 and a year of sleep. And underneath it, the entire time, was a 71-year-old woman who could not think of any other mechanism for saying, "Talk to me." The 4 months between the Guardian's report in July and the hearing in November were the part I was least prepared for, because I had assumed the report ended it. It did not end it. Camilla's solicitor sought a further hearing, and between July and November there were 2 more directions appointments, a witness statement exchange, and a bundle that grew from 4 centimeters to 11. And in that stretch, I did something I have not admitted to anybody except the therapist. I went looking. It started reasonably. Dialy's asked me in the August whether I had anything documenting the contact arrangements over the 7 years, because Camilla's statement asserted that arrangements had been irregular and ad hoc, and I knew that was untrue and needed to show it. So I went through 7 years of my own life for train bookings. I had them. Of course I had them. I book everything on the same account and I never delete anything. 41 journeys between 2019 and 2024, with dates and times and the price paid, exported to a spreadsheet in about 11 minutes. That was legitimate, and it went in the bundle, and it was devastating in a quiet way, because it showed 41 bookings made by me and none by her. But I did not stop there. I went through 7 years of my phone, every call to that number, logged with duration. 361 calls, of which I initiated 311. I went through my bank for the presents. I found the September birthday gift for every year from 2019 to 2024, bought by me, and I put the amounts in a column. I found the 8th of November call for each of the 7 years, and I highlighted them. And by about the 20th of August, I was sitting at a kitchen table at midnight with a spreadsheet of 7 years of unreciprocated effort, color-coded, and I had stopped preparing a case and started building a monument. Dialy's took about 90 seconds to see it. I sent her the whole thing, all 4 tabs, and she rang me the next morning and said, "I am going to use the train bookings and nothing else." I said the calls showed the pattern. And she said, "The calls show the pattern, and they also show a woman who has counted every telephone call she made to her mother-in-law for 7 years. And if that goes in the bundle, then the other side will put it to you in cross-examination, and they will be right too." I said something defensive. And Diley's Bramall said, "Mrs. Rook, you have spent 400 hours proving that you did everything. You did do everything. Nobody is disputing it. The question in front of this court is what is good for your daughter, and there is not one word in 4 tabs that is about her." I did not speak to her for about a day, and then I rang and apologized, and she said, entirely without drama, everybody does it. You did it in August, which is late. Most people do it in March. I asked her why people do it, and she said the thing that I have thought about more than any other single sentence from that year. She said, because being wronged is unbearable unless it is provable. So people go and prove it in enormous detail to nobody. The spreadsheet is still on my laptop. I have never opened it since the September. I keep it for the same reason, I think, that Delphine keeps a lined sheet of paper and Nils kept his notes. Because a person who has been through something builds a record, and the record does not stop being true when it stops being useful. But I know exactly what it is now. It is not evidence. It is 400 hours of a woman at a kitchen table at midnight demonstrating to herself that she had not imagined the last 7 years. And the reason I needed to demonstrate that is not Camilla. It is that from the 19th of December 2018, when a woman in my hallway suggested taking my daughter, I have never entirely trusted my own account of my own competence, and every time somebody put a word like volatile near me, it went straight to the same place. That is what the petition actually did. Not the money, not the leave, not the 11 months. It reached into a hallway in 2018 and pressed on something that had never healed. And I spent 400 hours in the August of 2025 color-coding train tickets to prove to nobody that I had coped. There is one more thing from those 4 months. In the September, Camilla's solicitor served a supplementary statement, and in it, she said something that I have never been able to decide about. She said that following her son's death, she had offered to take the child temporarily to allow the respondent to recover, and that this offer had been declined, and that she had never raised it again out of respect for the respondent's wishes. 7 years. She had never mentioned it once in 7 years, to me or to anybody, and then it appeared in a legal document in the September of 2025 as evidence of her good character. Diley's asked me how I wanted to respond to it, and I said nothing. She said, "You are entitled to say how that landed." And I said I know, and I still want to say nothing, because if I explain what that sentence did to me in 2018, then this becomes a case about my feelings, and it is a case about my daughter, and I would rather lose the point than win it that way. That is the single most grown-up decision I made in 11 months, and it took 11 months to be capable of it, and Diley's wrote back one line, "Agreed." Nothing said. It never came up again. The judge did not mention it. It sits in a bundle in a lever arch file in a cupboard in my house, and nobody has ever read it except 4 people. And on the 14th of December, when I rang Camilla and stayed in the room, I did not raise it then either. I have decided that some things you win by leaving in the file. People who hear a version of this always want to know whether she won or I won, and it is the wrong frame, and I have stopped answering it. On the paper, I won. The order she sought was refused. The contact reverted to what I had been organizing for 7 years. She paid her own costs, and I paid mine, and nobody was awarded anything. But she got what she actually came for. She came into that court because she could not say talk to me, and she left it with a daughter-in-law who rings her every Sunday and stays in the room for 50 minutes. If you had offered Camilla Rook that deal in February in exchange for withdrawing the petition, she would have taken it in about 4 seconds. So she won, comprehensively, by the only measure she cared about, using a method so destructive that it cost her 11 months, a great deal of money, and any chance of ever being able to say out loud what she was doing. That is what people do. That is the actual subject of this whole account, and it is not mothers-in-law and it is not courts. People almost never ask for the thing they want. They construct an elaborate mechanism that will produce it without their ever having to be refused, and the mechanism is usually so unpleasant that everybody involved mistakes it for the goal. She did not want an order. She wanted a Sunday phone call. And I did not want to protect her. I want to be exactly as hard on myself here. I wanted not to be in a room with her, and I dressed 7 years of avoidance up as mercy, and I was so convinced by my own version that when a judge complimented me on it in open court, I felt sick. 2 people who could not say a simple sentence, and 11 months of litigation to get to a place they could have reached in 2019 with one honest conversation. I have thought a great deal about whether I would do the 7 years again, knowing where it ended. The silence about the Fenwick Road. Yes, without hesitation. I would tell that lie again at the crematorium and every year after, and I would tell it on my deathbed. The system, no. And that is a distinction I could not have made in 2019 because I could not see that they were 2 separate decisions. I thought the secret required the distance. It did not. I could have kept the single largest fact of my life to myself and still had a conversation with that woman about her boiler. The reason I did not is not that it was impossible. It is that it was hard, and the system was easy, and once you have built a thing that works, you do not examine it. That is the practical content of everything I have learned, and it applies to a great deal more than mothers-in-law. Ask what your arrangement is for. If the honest answer is that it lets you avoid a specific conversation, then the arrangement is not kindness. It is architecture, and one day somebody will take you to court to get inside it. There is one thing left, and it is about the 8th of November. I rang her every year for 7 years on the day before she could ring me. I have described that in this account as a kindness, and for 7 years I described it to myself the same way. It is not. Ringing first means you choose the time. It means you have prepared. It means the call happens inside your frame and lasts as long as you decide, and the other person receives it. I was not being thoughtful. I was making certain that the single most dangerous conversation of the year could not arrive unannounced. I worked that out in the November after the hearing, the 7th anniversary, 4 days after the judgment, sitting with the phone in my hand at 9 in the morning. And I put it down and did not ring. And at 11:20, Camilla rang me, for the first time in 7 years on the day, and I let it ring twice and picked it up, and she said, I wasn't sure whether to, and I said, I know. I nearly didn't either. We talked for 2 hours and 11 minutes. Not about him mostly, about her sister in Kent, and about the house, and at one point about a coat she was thinking of buying and did not need. 2 hours on the 8th of November, and about 11 minutes of it was Toby. The 11 minutes were the hardest of the 7 years, and I got through them by holding on to one thought, which I am going to end on because it is the truest thing I know now. She was telling me a story about him at 9 years old and a bicycle, and she said he was so like his father, and I have nobody left who remembers that. And I thought, yes, you do. You have me. That is what I am for now. Not the keeper of the thing that would destroy her. The other one, the one who remembers the same man and can be asked. I have spent 7 years believing my job in this family was to hold something. It was not. Holding it was just the price. The job was always the 2 hours and 11 minutes, and I could have started them in 2019, and I did not, and she had to take me to court to get them. The thing nobody tells you about a grandparent case is that the law itself is genuinely difficult, and I want to set it out properly, because for 4 months I thought the court was simply being obtuse, and it was not. A grandparent has no automatic right to see a grandchild. That surprises people. In this jurisdiction, Camilla had to apply for permission even to bring the application, which she got, easily, because she is a close relative with an established relationship. Then the test is the child's welfare. Not the grandmother's rights, not my rights, whether contact is good for Imogen. And here is what makes it hard, and what I could not see in the march. The court starts from the position that contact with a loving grandparent is usually good for a child. That is not bias. It is decades of evidence. So the burden is not really on Camilla to show that contact is beneficial. It is on me to show that a court order is not necessary or not helpful, which means the only way I could win was to demonstrate that contact was already happening perfectly well without one. which meant that the better a job I had done for 7 years, the stronger my case was. I said something bitter about that to Diles in the April. I said, "So I am rewarded for the exact behavior that got me here." And she said, "Yes, and if you had been a worse daughter-in-law, you would be about to lose." The other thing I did not understand, until late, is what the order would actually have meant, and I had been fighting it for months on a feeling rather than a fact. A defined contact order is not a suggestion. It is an order of the court. If it says the child shall spend the first weekend of each month with the applicant, then that is what happens, and if it does not happen, the applicant can go back to court and I can be found in breach. Which means no rearranging for a school trip without her agreement, no swapping a weekend because Imogen has a match, no flexibility of any kind that Camilla does not consent to because the alternative is a breach. For a family living 2 hours and 10 minutes apart with a child in secondary school, that is not administration. That is handing a veto over your daughter's calendar to a woman who cancels 3 times a year for chest things. Diles made me write that out as a list in the May, 11 specific things that would become impossible. It went into my statement almost verbatim, and it is, I think, the part the judge actually cared about far more than anything about who canceled what. That is a lesson I have used since. Do not argue that a thing is unfair. Argue what it will specifically prevent in a list with dates. I want to say something about the money, because I have mentioned £11,400 twice and left it there. I earn a decent salary. I am a school business manager, and I am not poor, and I want to be honest about that before I complain, because there are women in exactly my position who could not have defended this at all. That is the part that frightens me in retrospect. If I had earned $12,000 a year less, I would have had to represent myself, or more likely I would have agreed to the order in the April, because the advice would have been that it is the same amount of contact and it saves £11,000. And I would have spent the next 7 years with a court order governing my daughter's weekends, granted to a woman who had described me as volatile, because I could not afford 4 days in a courtroom. Nobody in that process ever asked what I earned. The system does not have a mechanism for noticing that the outcome of a welfare decision about a child can turn on whether her mother has £11,000. Diles says this constantly and says it is the whole of family law, and that she has stopped being angry about it because anger is not sustainable across 31 years. I have not been doing it for 31 years. I am still angry about it. The last hearing had one moment I have not described, and it is the one Imogen asked me about years later. At about 3:30, near the end, the judge asked whether either party wished to say anything further. And Camilla stood up. Her own solicitor put a hand out slightly, the way you do, and she stood up anyway and she said, and I have the transcript, so this is exact. I would like to say that I have never thought Neve was a bad mother, and I do not want that on a piece of paper. She has been better to me than I have been to her, and I would like that written down too, please. The judge said, kindly, that it was noted. And that was the only time in 11 months that anybody said a true thing out loud in that building. Imogen asked me about it when she was 13, because she had asked what actually happened in the court, and I had, by then, decided to tell her properly. She listened to the whole thing, about 20 minutes. She asked 4 questions, and they were all good. And at the end she said, "So Granny stood up and said you were a good mum," in the middle of her own case. I said yes. And my daughter said, "That's mental." And then, after a moment, "That's kind of nice, though. That's like the nicest thing anyone's ever said about you," and she said it while she was losing. I have thought about that a great deal, because Imogen at 13 went straight to a thing it took me a year of therapy to arrive at, which is that Camilla's petition and Camilla's decency were never in tension. They came from the same place. A woman who cannot ask, and who therefore builds a mechanism, and who then, because she is not a bad person and never was, stands up in the middle of her own mechanism and tells the truth against her own interest. I told Imogen a version of it, not all of it. She does not know about the phone call from the car, and she is not going to. I have thought about that for years, and my position has not shifted. It is not information that improves anybody's life, and a 14-year-old who is close to her grandmother does not need to be handed the reason her father was on that road. When she is 30, if she asks me directly, and she may, because she is her father's daughter and she notices things, I do not know what I will do. I have a letter written. It has been in the same drawer for 4 years. It says what happened, and it says why I did not tell her, and it says that her grandmother did not kill her father. A bend in a wet road did, and that the two facts are allowed to sit next to each other. It is addressed to her, and it is not to be opened until after Camilla dies, and Diley's has a copy with my will, and she thinks it is a bad idea, and she has said so in writing, which is how solicitors disagree with you. She may be right. It may be a coward's way of telling the truth, a confession scheduled for a time when nobody can be hurt and nobody can ask me anything. But it is written down, and it is dated. And if I go first, then Imogen, at some point in her 40s, will find out that her mother knew something for 30 years and carried it, and that the carrying was the choice and not the accident. That is the most honest thing I can do with it. I am aware it is not the same as honesty. 2 years on, here is what the Sundays are actually like, because I have made them sound like a resolution, and they are a practice. 6 o'clock. Imogen takes it first, for between 11 and 40 minutes depending on her mood, and I no longer leave the room and no longer stay in it on principle. I am wherever I am. Then she brings the phone to me, or shouts, or increasingly just puts it on the side and wanders off. And I pick it up in Camilla, and I talk for somewhere between 20 minutes and an hour. The content is genuinely nothing. Her neighbor's extension, a program she is watching, a woman at her church who has strong opinions about the flowers, my work, which she asks about specifically and remembers the details of, which nobody else in my life does. About once every 6 weeks it goes somewhere real. Her sister's health, whether she should stop driving, which is coming and which she knows is coming. Once, in the spring, whether she was a good mother, which she asked at 7:10 on a Sunday out of nowhere, and which I was not remotely prepared for. I said, "You were the mother of a man who rang his wife from the car to say he did not want to say something he could not take back. Whatever that is, it came from somewhere." She was quiet for a while, and then she said, "That is a very careful answer, Neve." And I said, "Yes." And she laughed, genuinely, and said, "Well, fair enough." That is the closest we have ever come, and it is closer than I ever intended to go. There is a thing that happens now that did not used to, and I did not engineer it. She rings me, not on Sundays. In between, about twice a month, for no reason, usually at an inconvenient time, to tell me something small. The first time it happened, in the February after the hearing, I saw her name on the screen at 4:30 on a Wednesday, and my entire body went cold, because in 7 years that number had only ever appeared when something was wrong. It was about a coat. She had bought the coat, the one from the 2-hour phone call on the 8th of November that she was thinking about and did not need. She had bought it in the sale and she wanted to tell somebody. I sat in a school car park and listened to a 72-year-old woman describe a coat for 11 minutes, and I could not speak for a while afterwards. Because that is what the whole 11 months of litigation had been for. Not access, not an order, not a schedule of contact. Being somebody, a person rings about a coat. If there is a thing I would want anybody to take from this, it is not about grandparents, and it is not about courts. It is that the elaborate mechanism is almost never the goal. Camilla did not want an order. She wanted to be rung about a coat. She could not say that, so she built a legal process, and the process was so ugly that both of us mistook it for what she wanted. And I spent 11 months and £11,000 defeating a machine that had been constructed for the sole purpose of extracting a phone call. And I did the same thing in reverse. I did not want distance from that woman for its own sake. I wanted not to be in a room where the Fenwick Road might come up. So I built a 7-year logistics operation and called it generosity, and it was so efficient that I was proud of it in front of a guardian. 2 people, 1 grief, and neither of us able to say a sentence of about 9 words. So when somebody in your family constructs something enormous and hostile and disproportionate, and you are absolutely certain they are being unreasonable, and they may well be, it is still worth asking what 9-word sentence they were unable to say. The answer is usually available. It is usually smaller than the machine, and it is usually something you could have given them for nothing at any point in the previous 7 years. Imogen is 14 and rings her grandmother herself and organizes Christmas and has opinions about her own hair, which is currently long again, which Camilla has never mentioned once. I asked her about that, about the haircut in the October on a Sunday before Imogen came down. I said, "You never said anything about her hair growing back." And Camilla said, "No." "Why not?" And my mother-in-law said, "Because it was never about the hair, Neve. It was about the fact that she rang and told you first. She had gone quiet on that phone call in the August because an 11-year-old had rung her, off her own bat, delighted, to tell her about a haircut. And Camilla had realized, on the phone, listening to her granddaughter, that she was hearing about it second. That is what set off 11 months of proceedings, not the hair, being second. I said, "You were second because I was standing in the hairdresser's paying for it." And she said, I know that now." I keep thinking about the 4 minutes and 11 seconds. He rang me from the car at 10:30 at night to say that he was coming home, because if he stayed, he would say something he could not take back. For 7 years, I read that as being about her, about what he would have said to his mother. I do not read it that way anymore, and the change happened somewhere in the 2nd year of Sunday phone calls. I think he was frightened of what would happen to him if he said it, not to her. Because a man who says the true thing to Camilla Rook at 10:30 at night in a kitchen becomes, permanently, the man who said it, and my husband had spent 36 years being the person who did not. He got in a car instead. He chose 2 hours and 10 minutes of wet road over 9 words, and I have spent 7 years believing that was restraint, and I now think it was the same avoidance I have been describing in myself for this entire account, in a different shape. That is my family. That is the actual inheritance. 3 generations of people who would rather build something, a list on a clipboard, a legal petition, a 7-year logistics operation, a drive home in the rain, than say a short sentence out loud to somebody who is standing in front of them. Imogen rang her grandmother about a haircut without being asked, and I have thought about that 1,000 times since, and I have come to believe it is the single most hopeful thing that has ever happened in this family. She just said it. She wanted to tell somebody, so she rang and told them. Nobody taught her that, certainly not me. I want to write down what I would tell somebody who has just been served, because 4 people have now asked me, and I have never had it in one place. The first thing is the one nobody believes. This is probably not what you think it is. I spent the first fortnight believing somebody was trying to take my daughter. That is what everybody thinks when a legal document about their child arrives at 6 in the evening. It is almost never true. Read what is actually being asked for, out loud, twice, and then ring somebody and get them to tell you what it means, because your own eyes at 11 at night are not reliable. The second is, get the right kind of solicitor, and the right kind is not the most aggressive one. I saw one other before Diley's. He was very confident, and he used the word fight 9 times in 40 minutes, and he told me we would go at her hard on the cancellations. He was not wrong on the facts. He was wrong about the room. Family courts are not adversarial in the way television has taught everybody, and a solicitor who arrives swinging in a welfare matter marks you, and you will be the one who lives with the mark because it is your family and not his. Diley's asked 9 quiet questions in 11 minutes and did not raise her voice once and won it on the transcript. The third thing, and it is the most important and the hardest, whatever the true and devastating fact is that you are holding about the other party, and you will be holding one. Everybody in a family dispute is holding one. Decide in the first week whether you are going to use it, and then do not revisit that decision every night at 2 in the morning for 11 months. I did revisit it, every night, for 11 months. That is what actually exhausted me, not the hearings, not the bundle, not the money. It was the nightly re-litigation of a decision I had already made, because the thing about a weapon you have chosen not to use is that it does not go anywhere. It sits there, fully loaded, being available every single night, and each night you have to choose again. I would tell somebody, make the decision once, write down why, and put the paper somewhere. Then when it comes back at 2 in the morning, and it will, you are not deciding, you are remembering a decision. That is a completely different weight. I did that in about the August, on Diley's suggestion, and I have the piece of paper. It says 4 lines. The last one says, because he decided not to, and it is not mine to overturn. I read that 11 or 12 times between August and November, and it worked every time. The 4th is about the child, and I got it wrong for 5 months. Do not discuss the case does not mean do not be a parent. It means do not discuss the case. You are still allowed to tell her off about the towels. You are still allowed to have a bad Tuesday. You are allowed to say, this is a stressful time for me, and it is not about you, and I am sorry I was short. I stopped doing all of that in February because I heard the instruction as be beyond reproach, and my daughter spent 5 months living with a stranger who never raised her voice, and she noticed within weeks and told me I had gone weird. The guardian would not have marked me down for ordinary parenting. He would have marked me down for exactly what I was doing if he had seen it. A woman performing an unnaturally calm household for a man with a notebook. The 5th is practical and small, and it saved me more than any of the others. Keep one person who does not know. Kemi rang every Thursday for 9 months and asked about the case once a fortnight and did not listen to the answer. And that hour was the only hour in the week where I was a person and not a respondent. Everybody else, my sister, my mother, 2 friends from work, became, without meaning to, part of the process. They asked how it was going. They were kind about it. And every single conversation confirmed to me that this was the thing my life was now about. If you have somebody in your life who is bad at emotional conversations and good at nonsense, promote them immediately. They are worth 4 therapists during a court matter. And the last one is not advice. It is just the thing I did not know. It ends. That sounds stupid written down. But somewhere in about the July of that year, I genuinely stopped believing it would ever be over, and I have since talked to 2 other people who described exactly the same thing, and one of them used the phrase I could not picture a Tuesday afterwards. Neither could I. From about month 5, I could not imagine an ordinary week in which this was not happening. The bundle had become the weather. And then there was a Thursday in the November, 9 days after the judgment, and I was in the kitchen at about 7 in the evening doing something with a chicken, and I realized I had not thought about it all day. Not once in 14 hours. I stood there with a chicken in my hands and cried for about 4 minutes and then finished the dinner. And Imogen came in and asked what was for tea, and I said chicken, and that was the actual end of it. Not the judgment, not the corridor. A Thursday in November, 14 hours, and a chicken. The bundle is in a cupboard under the stairs in a lever arch file, and I have not opened it since 2025. I know exactly what is in it. 11 pages of petition, a guardian's report, 2 witness statements, 41 train bookings, a schedule of the 11 things a defined order would have prevented, and a supplementary statement containing 1 sentence about the 19th of December 2018 that nobody ever read out loud. Camilla asked me about it once, on a Sunday, in a completely ordinary voice in about the 2nd year. She said, "Do you still have all the papers?" I said yes. And she said, "So do I, in the spare room. I have thought about burning them about 11 times. And I said, "Don't." She said, "Why not?" And I said, "Because in about 15 years Imogen is going to want to know what actually happened, and she is going to get my version and your version, and neither of us will be reliable by then. Let her have the file." There was a pause on that line, and then Camilla Rook said, "That is a very cold-blooded thing to say about your own family, Neve." And I said, "Yes, it is also the only thing I have got that is not somebody's opinion." She kept them. They are in her spare room and mine are under my stairs, and one day my daughter will have both, and she will read 11 pages in which her grandmother called her mother volatile and a transcript in which her grandmother stood up and said the opposite while losing. I think that is a fair inheritance. It is more than either of us was given. There is one more person in this, and I have left her out because she is difficult to place, and it is not fair to end without her. My mother. She lives 11 minutes away. She is 69. She had Toby's death very badly, in the specific way that mothers-in-law who liked their son-in-law do, and she has been the practical spine of my life since 2018. The school runs, the Tuesdays, the standing in my kitchen putting shopping away without being asked. And she was, throughout the 11 months, absolutely useless. Not unkind. Worse. She was on my side so completely, so uncritically, so immediately, that I could not think in front of her. Every time I said something about Camilla, she agreed with it and improved it. If I said the petition was unfair, she said it was wicked. If I said Camilla was frightened, she said Camilla was manipulative and always had been, and she had said so in 2009. I stopped telling her things in about the May, not out of anger, because I noticed that after 20 minutes with my mother I was angrier than when I arrived, and that the version of Camilla I left her house with was not one I recognized. She has never forgiven me for the Sunday phone calls. That is the honest state of things now, 2 years on. She thinks I have been extraordinarily weak, and she says so about twice a year, and I have stopped defending it. Because you cannot explain to a woman who loves you that the person who supported you unconditionally through a difficult year made it harder, and that the friend who refused to discuss it at all is the reason you got through. That is not a criticism of my mother. She did what love does. But there is a kind of support that is really just amplification, and if you are in something like this, you will need to know the difference, and you will have to work it out alone because you cannot possibly say it out loud to the person doing it. I will finish where it started, which is a word in a document. Volatile. I have thought about that word for 4 years. I have looked it up more than once, which is embarrassing to admit. It means liable to change rapidly and unpredictably, especially for the worse. It was not true of me, and a court found so. But I have come to think it was the truest word in the entire 11 pages, and that Camilla's solicitor, who never met me and who was writing to a formula, accidentally wrote down the actual condition of that family. Because we were volatile, all of us for 7 years, not loud, not chaotic, underneath. A widow holding one enormous fact she could not say. A grandmother holding a hope she could not ask for. A man who had chosen, 36 years running and finally in a car on a wet road, not to say the thing. And a child in the middle of it who had never once seen 2 adults disagree, and who told a guardian so, and who won us the case by describing the exact deformity. A house where nobody says anything is not a stable house. It looks stable from outside, which is the whole problem. It is a room full of unsaid sentences with a very thin lid on it, and it stays that way right up until somebody hires a solicitor or gets in a car. Volatile. She was right, her solicitor was right, and not one of them knew why. Camilla is coming for Christmas in 3 weeks. She is getting the 9:10. Imogen arranged it in a 40-minute phone call from her bedroom with the door shut and told me afterwards, briskly, like a woman confirming a delivery. There will be a list. There is always a list. She brings it now instead of putting it on the wall, which she thinks is a concession and which we all pretend not to notice. And at some point in the 4 days, she will say the thing she says every year, which is that she does not want to be any trouble, and I will say she is not, and neither of us will mean it as a formality anymore. I do not know how many more of these there are. She is 73, and the memory thing is real, and the driving is going to have to stop. What I know is that the number of Sundays remaining is finite and countable, and probably smaller than I would like, and that for 7 years, I spent every single one of them handing over a telephone and leaving the room. That is the thing I would undo. Not the silence about the Fenwick Road. I would keep that, and I will keep it, and it will go in the ground with me or in a letter in a drawer. The room, I would undo leaving the room. 7 years of Sundays at 50 minutes each is about 300 hours, and I gave them away because being in the room meant risking a conversation with a woman I was frightened of hurting, and I called it protecting her, and my daughter watched me do it every week of her childhood and drew her own conclusions. She rang about a haircut. That is what I have got out of all of it. Somewhere in that house, a child learned, from nobody, that when you want to tell somebody something, you simply ring them and say it. I have no idea where she got it. It certainly was not from her father, and it was not from me, and it was not from the woman who sued me to get a phone call she could have had for free in 2019. But she has it, and in about 4 years she is going to leave home and take it with her, and that will be the first person in 3 generations of this family to walk out of the door without a mechanism. I have not written about the anniversaries properly, and there are 7 of them in this account, so I will. The first one, 2019, I did badly. I took the day off work and did not plan anything and spent 11 hours in a house on my own while Imogen was at nursery, and by 3 in the afternoon I had cleaned an oven that did not need cleaning. The second one I did worse. I went to work. I thought that would be better, and it was not. I sat in a budget meeting on the 8th of November 2020, and nobody in that room knew, because I had told nobody at that school. And at about 2:30, somebody made a joke about a spreadsheet, and I laughed and then had to leave the room. The third one I got right by accident. Imogen was 6, and she asked, at breakfast, whether we could do something for Daddy. Not sad. Practical, the way she is. And we drove to the coast and ate chips in the car in the rain, and she talked for 2 hours about a girl in her class who had bitten somebody. That is what we have done every year since. Chips in the car. It is now completely non-negotiable and has survived her becoming 14, which I did not expect, and last year she reminded me about it in October. Camilla has never been part of it. She has never asked, and I have never offered, and I have thought about that a great deal since the Sunday calls started, and I have decided it stays as it is. That day belongs to 2 people. The card, though. She sent a card on the 8th of November every year for 7 years, and every card said something specific about him. Not a general condolence. A memory, a different one each time. 2019, about him refusing to eat anything green until he was 9. 2020, about a school play in 1993 in which he had one line and delivered it to the wrong side of the stage. 2021, about the summer he built a raft with 2 other boys and nearly drowned in a reservoir. 2022, about his hands, which were exactly Imogen's, and which I had noticed and never said to anybody. I kept all 7. They are in the drawer with the letter. And what I understood, in about the 3rd year of Sunday phone calls, is that the cards were the same thing as the petition. A woman who cannot say I am still here and I still think about him every day, constructing a mechanism that says it for her, annually, in the post, without ever requiring a reply. She never once asked whether I got them. 7 years. I never once said thank you. That is not the worst thing in this account, but it is the one I would most like back. I said thank you in the 2nd year of the calls. On the 8th of November, in the 2 hours and 11 minutes, right at the end, and I made a mess of it. I said the cards, every year. I never said anything about them, and I should have. And there was a pause, and Camilla said, I wasn't sure you were reading them. I said, I've got all 7. And my mother-in-law said, oh. And then, after a moment, in a completely different voice, oh, that's right. Well, good. And then she changed the subject to her neighbor's extension, which she does when something has landed. And I let her, because I have learned that with Camilla you deliver the thing and then leave immediately. And if you stay to watch it land, she will take it back. The last thing, and then I am finished. 2 summers ago, Imogen went up on her own for the week, as she has since she was 7, and she came back with a photograph in her bag that Camilla had given her. It is Toby at about 30, in a kitchen I do not recognize, holding a mug, laughing at whoever is taking it. I had never seen it. In 11 years of marriage and 7 of widowhood, I had never seen that photograph, and Camilla had it in a box in a spare room 210 miles away. Imogen said, Granny says there's about 400 more. 400. I rang her that Sunday and asked, and she said yes, there were boxes, and then she said the thing that has organized the last 2 years of my life. She said, I didn't know if you'd want them. You never asked about the old ones. I never asked. 7 years, and I never asked the only other person alive who had his childhood, whether she had any pictures of it. Because asking would have meant sitting in a room with her going through boxes, and I had built an entire architecture to make sure that never happened, and it worked perfectly, and it cost me 400 photographs of my husband as a boy. We are doing them now, 2 or 3 a Sunday. She describes them and I write down what she says, because her memory is going and mine is not, and at some point in the next few years, I will be the one who knows which one is the raft and which is the school play. That is the actual ending of this story, and it took a legal petition, 11 months, 11,400 pounds and a corridor. A woman with 400 photographs, and a woman who never asked, on a telephone on a Sunday, going through them one at a time while there is still somebody to say who is in them. Diley's Bramall retired last year, and I went to the thing they had for her, which was in a room above a pub with about 40 people in it, most of them lawyers. I was the only client there. I know that because I asked, and she said, "You're the only one I invited," and would not explain why, and then explained why about 2 hours later when she had had a drink. She said, "Because you're the only one in 31 years who did the thing I tell all of them to do." I said, "Which thing?" And Diley said, "You didn't use it." I had never told her what it was, not once in 11 months. I had said in the first meeting in February that there was something I knew about my mother-in-law that would end her, and that I was not going to use it, and Diley's had said, "Then I don't want to know what it is," and we never spoke of it again. I said, "You don't even know what it was." And she said, "No." And I have had 111 clients tell me they had one, and about 90 of them told me what it was inside 4 weeks, and about 60 used it, and I have watched every single one of those 60 win the case and lose the family. She had another drink, and then she said the last piece of professional advice she ever gave me, which was not advice, it was just true. "The ones who use it always think the family was already lost," she said. "That is how they give themselves permission, and they are wrong about half the time, and they do not find out which half until about 4 years later, and by then it is not recoverable." I think about that at Christmas, when Camilla is in my kitchen at 7 in the morning, making tea nobody asked for and reorganizing a cupboard. Because I am not a saint about it. I want to be extremely clear at the end here. She still drives me mad. There is a specific way she says, "Well, if that's how you do it about the oven that makes something behind my eye twitch." And last year she rewashed a tea towel I had already washed, and I stood in the utility room and said a word out loud that I would not want Imogen to hear. 2 years of Sunday phone calls have not made me love her. I want to be honest about that because it would be a nicer ending if they had. What they have done is much smaller, and I think much more durable. I no longer look at Camilla Rook and see the Fenwick Road. For 7 years I could not look at that woman without seeing a wet bend at 4 minutes past 11, and I could not tell her that, and so I handed her a telephone and left the room, and I called it kindness for 7 years. And now, most weeks, she is just a difficult 73-year-old who is frightened of being left, and who has 400 photographs of my husband as a boy, and who is the only other person on this earth who knows what he was like at 9. The road is still there, I still know. It has not gone anywhere and it never will. It is just not the first thing anymore. That took 7 years of silence, 11 months of litigation, 1 corridor, and about 111 Sunday phone calls, and I would not have got there by telling the truth in 2018. That is the part I still cannot fully square, and I have stopped trying. The kindest thing I ever did was also the most avoidant, and it worked, and I do not know what that means. Imogen asked me last month, out of nowhere in the car, whether I was happy. 14 years old, headphones in one ear, not looking at me. I said that was a big question for a Tuesday. And she said, "You've just been in a better mood for about 2 years, and I wondered why." I said something about work. And my daughter said, "It's since you started talking to Granny properly." I did not answer that, and she did not push it, and we listened to whatever she was making me listen to for the rest of the way home. But she is right, and she is 14, and she noticed a change in her mother's mood, and correctly attributed it to a weekly phone call with a woman who once took me to court. That is what she will take out of this house. Not the case, which she barely remembers, not the guardian or the bundle or the word volatile. She will remember that her mother and her grandmother had something badly wrong between them for years, and that it got fixed, slowly, in 50-minute pieces on Sunday evenings, by two people who finally stayed in the same room. That is a better inheritance than the file under the stairs. And if she ever ends up in her own version of it, some decade from now, with some person she cannot say 9 words to, I would like her to remember that the fixing took 2 years of Sundays and nothing dramatic happened in any single one of them. That is how it goes, not a corridor, not a judgment. 50 minutes at a time about a coat until one day you notice you are not carrying it in the same place anymore. There is a question I get from people who have heard the outline, and it is always the same question, and I want to answer it properly before I stop. They ask, "Were you not furious?" And the answer is that I was furious for exactly 11 days in February, and then almost never again, and that this surprised me more than anything else in the whole story. The 11 days were real. I have never been angrier in my life than I was in that fortnight. I wrote 3 emails to Camilla that I did not send, and one of them was 2,000 words long and contained the Fenwick Road in the 4th paragraph. I still have it. It is in a folder called Do Not Send, which contains that one document and nothing else, and I have opened it twice in 4 years and both times closed it again. And then in about the 3rd week of February the fury went, and what replaced it was something much stranger and much less satisfying, which was recognition. Because I read paragraph 9 of that petition, the one about unilateral decisions regarding the child's appearance without consultation with the paternal family, and somewhere underneath the outrage, a very quiet voice said, "She is not wrong that she was not consulted. She was not consulted. About anything. Not the haircut and not the school and not the football and not one single decision I have made about my daughter since 2018, because I had built a 7-year system in which she received information and never participated in it. That does not justify a legal petition. I want to be clear. There is an enormous distance between not being consulted and going to court. But she was describing, in legal language, in a document drafted by a solicitor who had never met me, a thing that was actually happening. And you cannot stay furious with somebody who is describing something real. You can stay furious with the method. I am still furious with the method. The other question people ask, usually more carefully, is whether I regret keeping the secret. No. Not once, not at 2 in the morning, not in the 11 days in February, not in the walk round the block in May. I have regretted almost every other decision in this account. The system, the room, the 7 years of not asking about photographs, the 5 months of being weird in my own kitchen, the 400 hours color-coding train tickets. But I have never for a single second wished I had told Camilla Rook what her son said in a car at 10:30 at night. And I think that is because it is the one decision I made purely for somebody else with nothing in it for me at all. Everything else I did in those 7 years had a second function I would not look at. The silence did not. The silence cost me constantly and returned nothing, and it is the only thing in this whole account I would do identically. That is worth knowing about yourself, if you can find it. Most of what we call kindness has a second function. Find the piece that does not, and hold on to it, because on the bad nights, it is the only evidence that you are not entirely constructed out of self-protection. Camilla comes on the 22nd, 9:10. There will be a list, and she will bring the box with the next 40 photographs in it, because we are up to about 1988, and she has started sorting them in advance, which she pretends is not a project and which is obviously a project. Imogen will do the tree with her, which they started 2 years ago, and which has become a thing with rules that I am not allowed to participate in. And on the 24th, we will have the argument we have every year about whether the turkey needs to go in at 6 or 7, and she will be wrong, and I will do it my way, and she will say, well, if that's how you do it, and I will not say anything at all. That is the whole of it. That is what 11 months in a family court and £11,400 bought. A difficult woman in my kitchen at 7 in the morning, being wrong about a turkey, with a box of photographs of my husband at 9 years old on the table beside her. I would pay it again. I would not enjoy paying it again. If you have got this far, I imagine you have somebody. Not necessarily a mother-in-law. A brother, a father, a person you were once close to and are now polite with, and there is one sentence between you that neither of you has said, and around that sentence you have both built something enormous, a schedule, a distance, a set of rules about what gets discussed at Christmas. And you have probably told yourself, as I did for 7 years, that the arrangement is a kindness, that you are protecting them, or the children, or the peace. Ask yourself the honest question, not whether the arrangement is kind, whether it is for you. Because the terrible thing I learned, at 41, in a corridor, from a woman I had spent 7 years managing, is that the person on the other side of your careful arrangement can usually feel it. They cannot name it, and they will not raise it, because people who are being managed almost never can. But they know, and they will eventually do something enormous and disproportionate and inexplicable to get out from under it. And when they do, everybody will look at the enormous thing and nobody will look at the arrangement, and you will get a great deal of sympathy that you have not entirely earned. She rang me about a coat. That is all she ever wanted, and it took a solicitor and 11 pages and a judge to get it, and I could have given it to her in 2019 for nothing. One last practical thing, because somebody reading this may be at the beginning of theirs rather than the end. Keep the dates. Not a diary, not a case file. I am not telling you to build what I built in August, because that took 400 hours and Diley's was right that it was a monument and not evidence. Just the dates, who canceled and when, who asked and when. One line in a notes app, 4 seconds, no adjectives. I had 7 years of train bookings by pure accident, because I never delete anything, and those 41 lines were the single most useful document in the entire proceedings, and they existed because of a habit and not because of foresight. If I had kept the cancellations as well, 5 words each, 3 times a year, Camilla's central allegation would have collapsed in February instead of November, and it would have cost about £11,000 less. The reason to do it is not that you expect a court. Nobody expects a court. The reason is that memory is not neutral, and both of you will remember the same 7 years completely differently, and a date is the only thing in the world that does not take a side. And then, having kept the dates, do the other thing, which is the whole point of this account, and which no amount of record keeping will do for you. Ring them. Not about the thing. Not to resolve it, not to clear the air, not to have the conversation. Just ring them on a Sunday and stay on the line for 50 minutes about a coat. Because the file under my stairs proves I was right, and it changed nothing at all. And 111 phone calls about nothing changed everything. And I had both available to me from 2019. I chose the file for 7 years. She had to take me to court to get the phone call. I said at the start that this was not a story about a monster, and I want to be sure I have earned that. Camilla Rook put a word in a legal document that made me doubt my own temperament for 6 months. She let it stand from February to November. She did not withdraw when the Guardian's report came, which she could have done in July, and which would have saved both of us 4 months and several £1,000s each. Those are real things, and I am not going to soften them because we talk on Sundays now. What I am saying is only this. At the end of 11 months in a room where she was losing, she stood up without being asked and told a judge that I was a good mother. Nobody made her do that. It was against her own interest. Her solicitor put a hand out to stop her. And I have decided, over 4 years, that this is the sentence I am going to keep as the true one about her, and that the 11 pages were written by a frightened woman through a solicitor she was paying to make her sound reasonable. You are allowed to choose which evidence about a person you organize your life around. That is not naivety. It is not even forgiveness. It is a decision about what you want the next 20 years in your own kitchen to feel like. I chose the corridor, and the 2 hours and 11 minutes, and a phone call about a coat. She chose 11 pages. We both got what we chose, which is the only genuinely fair thing that happened in this entire story.